All right, let's proceed.
Good morning, Your Honors.
Morning.
My name is, may it please the Court, my name is Attorney Lauren Galvin, and I represent the Hingham Conservation Commission in this matter, which is the defendant appellant. We have appealed to overturn the decision of the Plymouth Superior Court, which did two things. First, it overturned the denial by the Hingham Conservation Commission of an order of conditions because it decided that the WPA deadlines could not be extended. The second thing the Plymouth Superior Court did in this matter was it overturned a separate enforcement order which was issued by the Conservation Commission for separate work because it said it was not based on substantial evidence. This case presents a novel issue of law here, whether the timelines of the WPA may be extended by agreement of the applicant and the Conservation Commission.
Could I just ask you a factual question? And it may be clear in the record, but I couldn't figure it out.
Yes.
The form that
Yes.
that doesn't have a signature. How does the
It's a one-page form.
Right.
It's at
How does that get to an applicant like Mr. Garrity? Does it come in a package?
Yeah, he would have to pick it up at the Conservation
But
Commission.
it comes with the application itself, with the NOI.
Yes, there's different forms they need. Some of them they have to get. Some of them are DEP forms, but yes, they can pick up all the forms at the Conservation Commission.
So that is one of the ones in the package of materials that he would have to pick up.
It's a separate freestanding form. It's APP 352, and it clearly says Hingham Conservation Commission waiver of the 21-day deadline.
So every applicant needs to fill that out?
They don't need to. They are all presented with this particular form.
And when you have the checklist, it has some language
Yes.
about I have done something, I have read
Read and
it.
signed.
Yes, yes, but the checklist is not, the checklist lists many things which an applicant may or may not need. This applicant clearly knew that they didn't have to check off every single item of the checklist.
Suggesting that he could have just left that blank
He
and
could have-
not submitted that form?
Yes, he could have. He could have written that.
How would he know that?
Well, the applicant had hired a consultant.
Well, all right, how would I mean, there's no direction that says you don't need to send this back. I mean, it's part of the form, it's part of the package, right?
Correct. However, there are several things that they wrote on the checklist that were not applicable to them. They could have written not applicable. The only thing, the Hingham Wetlands bylaw specifically says that the only things that are required are what is required by the Wetlands Protection Act. And under the Wetlands Protection Act, the only things that are required are the notice of intent and the plans. And actually, the Hingham Wetlands bylaw specifically states that. It says, the same notice of intent, plans, and specifications required to be filed by the WPA will be accepted as fulfilling the requirements of this bylaw. And the WPA doesn't require a waiver. Therefore, this savvy consultant should have known that he did not need to fill out the waiver. There's one other piece
No
of...
notice anywhere that tells the ordinary applicant you need not waive.
This is
Optional.
voluntary. This is voluntary.
There's one other piece of evidence that I wanted to point to your attention, which I did not point to your attention in my brief, and that's APP 337. And this is the form that the...
Could you tell us the record appendix number for
Oh,
that, the page
sure.
number for that?
Sure, it's APP 337.
So is it in the, okay.
Yes, it's in the appendix. It's titled The Review of Notices of Intent and Notification to Applicants.
I have to say that APP 337 is not in my appendix.
Yes, it is. Yes, it is.
Mine goes from APP 334 to APP 339.
There's 2 volumes.
Oh, okay, there's 2 volumes.
Yes.
Okay,
There's a thicker one.
I'm using the thicker volume.
Yeah, it's in there.
Well, it's not in mine, so, okay.
Okay, sorry. So what happened in this case, which we didn't go through all of this in detail, but I can explain it right now. On March 9th, he filed his application. The Conservation Commission reviewed that application and realized he was using outdated forms. So it said, your application is not complete. A few days later, on March 11th, he came back with the proper forms. He just was using forms that were a couple years too old, DEP forms and some other forms. But he would have received this review of notices of intent, which lists all the reasons they generally would deny a notice of intent as being incomplete. And the reasons listed are only things, the Form 3, that's a DEP form, that's the notice of intent form. Form 4, that's another form, and the rest of the items are plans and maps. So,
And other.
so that they would have known that that was not a reason that the for it to be deemed an incomplete filing.
Well, let me ask you this.
Yes.
Let's assume that Hingham had a rule that said, unless you sign the waiver, we will not consider your application.
Yes.
Would that be a proper waiver?
No.
Okay, so you prevail here only if it is a proper waiver,
Yes.
and is that because the word was used that was requested as opposed to required?
That's correct. It's requested. It's a clear one-page sheet, and it's clearly telling them what they're requesting be waived, the mandated 21-day deadline. They never raised an issue. They never said, we don't want to waive these deadlines.
I'm sorry, I thought they sent a letter right after the hearing saying we expect that the decision will be made within the 21-day deadline.
That was not a letter. That was an email from the consultant.
Okay.
Now, this is a brand new theory that has been raised on appeal. It was never raised in the court below. But what Garrity is saying in his brief here is that that email constituted somehow a withdrawal of the waiver. And if that was true, you would think they would have raised that argument below, but they never did. The email was an email chain regarding payments of invoices in peer review. That email is located at A220.
That's right. And in terms of the timing, that email came when in the 21 days?
About 35 days after the application was filed,
And before or after the hearing?
after the hearing.
But before the 21 days had run.
Before the second 21-day period had run. But what I'd like to mention is these conservation commissions only meet about twice a month. So they weren't going to meet again.
Was the date set for the hearing before this letter came in?
As the email explains, it was sort of tentatively scheduled for 4/20, but there was a town meeting and they were thinking of pushing it out further. But then the meeting does happen on 4/20. So yes, it was scheduled, and there wasn't another, I think there was only about 14 days in between this email, April 13th, and
So the email is a week after the hearing. The hearing was the 6th, right?
yes.
Is it your position that the written waiver essentially allowed for almost an unlimited amount of time, so that even if the decision came 22 days after the hearing, it was okay under the waiver?
That's correct, and I wouldn't say it was unlimited. They were, clearly, they issued the decision, they met on the 21st day, and they issued the decision the next day on the 22nd
Well,
day.
what's to prevent them from exercising or using an unlimited amount of time?
I mean, nothing is preventing them from doing that, but that was not their intent. As explained in the waiver, they had an increased number of filings, they were overwhelmed, and they were doing things as fast as they could.
What happens in the normal course if somebody does not execute one of those waivers, and the Conservation Commission is coming up on 21 days? Do they deny the application?
They would have to find a way to make the decision within 21 days. I mean, they could deny it, and then it could get appealed by the court and overturned if the grounds weren't strong enough for the denial.
Does that happen? They have to do something within the 21 days, or do they essentially get a waiver in virtually all cases?
They get a waiver in most cases in Hingham. They don't require it in all, and if somebody didn't want to sign it, they wouldn't make them, but people do waive
When
the
did
21
that come
days.
into effect, the waiver request, with respect to, what was the date?
Oh, it was filed right along with the notice of intent application.
No,
year,
what year?
Oh, 2009 we're talking.
But I mean, when did Hingham start asking people to sign waivers? Is that what you
Yes.
Yeah.
Unfortunately, I don't know that.
So does the record contain the wrong checklist?
Yes, it does.
Okay, could you just give me the site to the wrong
yes,
checklist
sure.
that was earlier signed?
Yes.
Okay, thank you.
The outdated checklist
Right.
was located at APP 350 and APP 351.
Thank you.
That doesn't mean that the waiver was at all changed. What they were talking about, some bylaw provisions had changed, which are separate from what we're talking about here.
Actually, they're different, because the one that's obsolete says, I have read the Hingham Conservation Commission's waiver, and the other one says, I have read and signed. So they actually are different.
Oh, that, they are different, yes. In that respect.
So how would you sign 352 without, well, of course, it doesn't even ask for your signature.
Correct. But he filled it out, and he signed the checklist.
Well, somebody filled it out, we don't know who.
The consultant did, we do know that.
Let me shift a little bit.
Yes.
Chapter 131, Section 40 does not have any express language in it that allows for the waiver, right?
That's correct.
Now, under Chapter 40A, Section 9, the zoning statute,
Yes.
that refers to the special permitting process, also has this language in it, like 13140, that if a decision is not made within a certain period of time, it will be deemed to be an approval. But that statute also allows for a waiver. It expressly provides for or an agreement to extend the time. The same is true under Chapter 41, Section 81U for the subdivision control process, where if a decision is not made within a certain period of time, it will be deemed to be an approval. But again, that statute contains language that expressly allows for an agreement to extend the time. This statute doesn't have that. Does that mean that waivers are impossible to obtain under Chapter 131, Section 40?
No, it doesn't.
Why not?
Because I've explained in my brief, under the Supreme Court case Mezzanato, the Supreme Court has explained that there's a presumption that you can waive any statutory provision. So unless the legislature has specifically stated that there's some reason why these deadlines shouldn't be extended, there's a presumption that they may be waived.
But the legislature has, in at least two other similar kinds of enactments, expressly said that you can waive. Is the absence of that language in this statute a statutory intent that it cannot be waived?
No, it is not. And I think those statutes actually point to, are good evidence that you can waive these types of deadlines. It's okay to waive timing provisions.
Well, they say it in there. They say it right in those statutes. This statute doesn't have that language.
That's true, but I think you have to look at what the purpose and intent of this statute was. That's what the case law tells us to do. And the purpose and intent of this statute is to protect the environment.
Okay, so the language in Chapter 40A, Section 9, and Chapter 41, Section 81U is unnecessary.
It is, yes. Because there's a presumption that you can waive any statutory provision, unless there was some sort of legislative intent that somebody could point to that said there's some reason why you can't waive them, you can waive them.
If you could turn briefly to the enforcement order.
Yes, yes, absolutely.
Because you don't have much time. Is the only evidence that the steps were widened that photograph?
No, absolutely not. The agent went and viewed the site and saw the stairs as they were before and saw the way they were after.
Does the record reflect evidence? The only evidence that you cited in your brief was go and look at those photographs, which I did, and they're from different angles, and I can't tell whether they're wider. Is there evidence apart from that says that they indeed were widened?
I mean, the evidence is that the enforcement officer went and had been viewing the site before, and then they, in the context of this other order of conditions situation, they were very familiar with the site. They had been there several times, and then suddenly they go back, and there's this big, huge deck and stairway up the coastal bank, which is a resource area. So, the evidence, there was the conservation commissioner was there taking those photographs.
Okay, now your brother says the deck was part of the application which he claimed had been waived.
And that's absolutely not true, because no dimensions of the order of conditions match up with that huge deck. The dimensions of that deck are bigger than any dimension in anything listed in the enforcement order. clearly it wasn't covered. And when he's saying it's covered by the order of conditions was for the pier out into the water. We're talking about activity up on the coastal bank. It's completely separate areas. There's no way the enforcement order could have covered the work that was done up on the coastal bank.
Can I ask you a question about that? There's the enforcement order. Mr. Garrity appeals. The Superior Court hears both the order of conditions and this enforcement order. If you just, in a case in which there's just an enforcement order and there's an appeal, what does the proceeding normally look like? I mean, is there an administrative ability to challenge that? In other words, if I understand this correctly, you have an enforcement order that checks off certain boxes,
Yep.
but there's no, at the administrative level, there's no proceeding in which people are introducing evidence at all. Is that right?
It's probably not as straightforward as the order of conditions procedure, but still, it's the same test of the substantial evidence, and you would look to the evidence that the Conservation Commission had to make that. That's what the court would look to. It's the same kind of certiorari.
So you would agree that substantial evidence is the correct, under this 249-4, you would
Yes.
agree that that should govern the enforcement order as well as the order of conditions?
Yes, and I can't think of a case that would have more substantial evidence than both the order of conditions and the enforcement order in this case. I mean, you don't always have photographs in the record.
Council will have to leave it there. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Matthew Watzke. I'm here on behalf of Michael Garrity, the plaintiff and appellee. Two questions before the Court. The primary ones is the deadline under the Wetlands Protection Act waivable, and in what circumstances, if it's not waivable in the way the statute is now, and under what circumstances could it be made waivable? I'm going to turn to a question that Justice Gantz raised a moment ago, and that's the question about the provisions in Chapter 40A and Chapter 41 of the general laws, the subdivision control law and the zoning law. It's an interesting history and a very good question. Back in 1959 in Pieper, and this is not in my brief, this is an issue that I further researched once I saw that the court had asked for amicus briefs on the question. It's PIE-PPER versus Planning Board Town of Southborough. It's 340 Mass 157. It was issued in December 1959. Dealt with a case in which the Planning Board had issued a denial of a subdivision approval without ever even holding a hearing. No hearing at all. And the question that the court ended up dealing with is whether the town should have then commenced an actual hearing, what were the remedies available, and the ruling included specifically the recognition that that there was no indication in the statute that any extension of time for board action is contemplated within the statute itself. That was the decision, page 164. The legislative response in 1960, less than a year later, it's Chapter 266, Section 2 of the Acts of 1960, was to amend Chapter 41, Section 81U to specifically insert the wording, or such further time as may be agreed upon at the written request of the applicant, with notice of such extension of the time shall be filed forthwith by the planning board with the city or town clerk. So how can an extension be granted under the Wetlands Protection Act of the 21-day deadline? Frankly, it cannot be, but it could be if the statute were amended to specifically allow for a voluntary agreement by the applicant to extend the deadline, where that agreement is with notice that you could deny, you could choose not to agree to it, that it's in writing, and that notice is given to the public as a whole. And this way it's constructive notice by filing it with the town clerk. And none of that happened here. And the reason that the notice is a key part is the comprehensive nature of the Wetlands Protection Act procedures. So that this court has recognized in a number of different cases, most recently in the Oyster Creek, that the Wetlands Protection Act is a comprehensive scheme designed to implement and regulations and protections for wetlands. And
but the problem is, though, that you signed you didn't sign it. Your client submitted a written waiver that was apparently intended to be relied upon by the board and presumably any abutters whose appellate rights might be affected. What are we to make of that? Isn't there almost like a latches kind of defense here?
No, Your Honor, I don't believe there's any latches here. As the court has noted in the argument just a moment ago, there was an email from the consultant to the Conservation Commission just 1 week after the hearing was closed that said, we expect that this decision is going to be issued within the 21-day time period. In fact, the Conservation Commission met and deliberated within that 21-day time period, and should they have been inclined to, they could have had a postmarked envelope available and could have issued the decision and gotten it in the mail.
But your expectation wasn't a withdrawal of your consent. It didn't seek to place. Isn't it too little, too late?
No, I think, Your Honor, that the email from the consultant was really more a recognition that, for all intents and purposes, the waiver had no effect.
Well, why didn't it just say so if that's what its intent was? I mean, it seems to me it's sort of a question. That's my understanding, right?
I can't put myself in the consultant's mind at that moment.
But I mean, more to the point, more to the point, how was the Conservation Commission supposed to understand that as a definitive withdrawal of waiver? I guess that's what it just is at best ambiguous.
Perhaps, Your Honor, it was ambiguous. The consultant made clear that I think that the deadline, he believed that the commission should issue the decision by that deadline. The commission absolutely got that email. They acted on other parts of it, and they didn't then respond to suggest that they were going to act at a later date anyway.
Well, they acted on the date that he said. He knew on the 21st day that it was denied. It just wasn't mailed until the next day.
Actually, he wasn't present when they
No, but his consultant was. His consultant was present, I assume, at the hearing.
The consultant was the author of the email. Right.
Well, does the record indicate that someone on behalf of the plaintiff was present?
I don't believe that the record indicates that, Your Honor, no.
So it should turn on that?
Pardon?
Well, I don't know. It seems that, if you have something that purports to be a waiver, and what you're saying is it was withdrawn, I guess I'm just troubled by the ambiguity of the withdrawal that you are claiming.
I think the question really, Your Honor, is whether a Conservation Commission is empowered to even impose a requirement that someone grant them a waiver.
Well, impose a requirement is different. The question is whether they can seek and obtain a waiver under the statutory scheme. You're saying they can't. Assuming they can, the question then becomes whether this waiver was valid, a voluntary waiver.
Right. Your Honor, let's assume for the sake of argument that this was a voluntary waiver, that the checklist that they provided, which says you must include all of the following, let's assume that doesn't mean anything.
I'd say that, but all right. We'll assume it's a voluntary.
So let's assume that it was voluntary. I believe that the controlling case there, by analogy, would be a case I've cited in my brief. That's the Beacon Hill Civic Association, 422 Mass 318.
And it's against public policy?
In 1996, where, yes, it's against public policy, where in that case there was an agreement between parties to work out the details of what a permit would issue. This was an alcohol beverage control proceeding, and they waived the requirement for a public hearing altogether. And that was found, even though it was voluntary, it was agreed upon by the parties, that was found to be against public policy to waive a public hearing.
Why is the public served by the 21-day requirement. It seems the only party that's served is the property owner, who's assured of a prompt answer to the question of, does my intended improvement violate the Wetlands Act?
The Wetlands Protection Act creates a whole set of procedures, Your Honor, for how different parties are able to participate in it. So it's not just the applicant and the owner, who are actually viewed as separate parties, who are entitled to participate in the proceedings and to be able to file appeals. You can have the owner, the applicant, DEP itself, abutters, persons aggrieved, which could be someone who owns property down gradient or adjacent to it that's not directly in a butter, as well as 10 citizen groups, which is under Chapter 214, Section 7A. All have the right to request appeals to DEP, and then if they then disagree with DEP's decision to request adjudicatory hearings, they know, because of the way the statute is crafted, that the hearing has to commence within a certain time period. They're given public notice of when the hearing will commence, and they know that there's a specific deadline after the hearing is closed.
Presumably, they're not going to appeal until they have a copy of it. Presumably, they're not going to appeal until they have a copy of the decision.
Actually, Your Honor, that's not true.
Okay. Oh,
Because
interesting.
that's not true.
I didn't know you could appeal without a decision.
All of these parties have a right to participate in this and to file appeals, and
even before the board decides?
And DEP's rules and regulations have specific provisions in them, in the procedures. That would be 310 CMR 10.05. I can't give the specific subsection. That if a Conservation Commission has not acted in a timely manner, that any of these parties have a right to request superseding order of conditions from the DEP.
Oh, I see what you mean.
All right? Yeah. And in fact, that's how my client appealed the Conservation Commission's decision under the state law. We filed a request for a superseding order of conditions specifically based on the Conservation Commission's failure to act within a timely manner, within the 21 days, and the DEP accepted that and proceeded to issue a superseding order of conditions, which, by the way, became final. The Conservation Commission never appealed it.
So your view is that no matter how complex the application, no matter how much time it may take for a volunteer board to consider it, that the board cannot ask someone if they'll waive the time limit so they have adequate time to consider it?
Your Honor, there is lots of time. There's plenty of time available for the Conservation Commission to hear the facts. They can, once the hearing is started, the Conservation Commission can request extensions and continue its hearing to another date, just as is provided under the open meeting law, and have their hearing continue for 1 or 2 or 3. I've seen hearings that continued for 10 separate dates over a matter of months.
But doesn't the statute say if a decision isn't made?
Exactly. But that's the next piece of it, is that once the hearing is closed, though, the statute is explicit that once you've closed the hearing, you have to issue your decision in 21 days. And if you don't issue the decision in 21 days, and if this waiver, as counsel has argued in the reply brief, if the waiver is irrevocable, and the Conservation Commission takes longer, then how is the applicant and how is anybody else supposed to know when the decision is actually going to issue, and what are their rights?
So
you could have the order not issue for 1 day longer, a week, a month, 6 months, a year. You'd never know when it would issue.
Let me ask you this. In terms of continuing the hearing, would it be all right under that theory that if there's a hearing on April 6th, and so then on April 21st, it's on the agenda, and the chairman says, we're going to put this over until May 3rd. I mean, could you just do that until they're finally ready to make a decision? Would that be okay?
If the hearing were left open, Your Honor, yes.
I mean, isn't that really just a technicality?
Well, no, because the applicant has a right under DEP's regulations to decline to have the hearing continued beyond a certain
Well, I
point.
would think you might have the same thing with a waiver. I mean, you could withdraw the waiver.
I'm sorry, I couldn't hear you.
You could withdraw the waiver in the same way, right?
You could withdraw the waiver? I So an applicant could withdraw a waiver, but counsel is saying that waivers once granted are irrevocable in the way of, all the cases that she cited on that relate to private rights. So if you've waived a right to a trial by jury and now you're standing before the judge and say, I've changed my mind, I want a trial by jury, you've waived that private right. But the case law on public policy deadlines is that you can't waive it.
Well, assume for a moment you prevail in this case. What's the rule going to be going forward? That there can never be a waiver, or that it must be entered into and agreed to knowingly? What would the rule be?
I think, Your Honor, under the Beacon Hill Civic Association line of cases, that thought process that unless the Wetlands Protection Act were amended to specifically provide that extensions of this deadline are permissible, just as there is a provision in the Zoning Enabling Act, Chapter 40A, and in the Subdivision Control Act, which is Chapter 41, Section 81U, that unless you have the Wetlands Protection Act amended in a way consistent with that waivers are simply not permissible. And everybody should know you have to act within the 21 days.
Go ahead. But before your time runs out and is running out, can I turn just for a second to the enforcement order? The deck. Was the deck included in the NOI?
Yes, Your Honor. The deck was included in the NOI as, in essence, an after-the-fact filing. It had been built before the notice of intent was filed, and it was a mistake. And he filed the notice of intent seeking approval for the deck, and then as the process went forward and the design was refined, the location for the deck was adjusted on the plan so that it could get permitted. And
Was the deck moved?
no, pardon?
But you said the deck was already built.
Well, it was built before the notice of intent was filed, and this is not at all an unusual circumstance.
No, I understand, but you said that there was an amending of the plan to move the deck. So
Yes.
that's what I'm confused about.
Well, he's not able, or wasn't able to proceed with moving it until after all the permits were in place. So that's the intention, is once everything is finalized, then he'll go ahead and the deck will be moved or adjusted in size accordingly.
A quick question. Oh, sorry.
Let me just ask you one final procedural question. The statute says within 21 days of the receipt of a written request, the Conservation Commission shall make a written determination as to whether the section is applicable. The statute then goes on to say if a Conservation Commission has failed to hold a hearing within the 21-day period, or after holding such hearing has failed within 21 days therefrom to issue an order. Is there a preliminary determination that has to be made within the first 21 days, and during that 21 days, if the Commission makes a determination that, yes, it applies, what your project applies, they then proceed to further administrative proceedings? Is that the way it works?
The DEP has drafted regulations that elaborate on and explain the procedures. So in DEP's regulations, you have actually two separate filings that can be made. The first that you've just noted, Justice Spina, is a request for a determination of applicability. So you have you file a request for determination. Does the act apply or does it not?
Are we concerned with that?
And we're not concerned. We're not concerned
okay.
with that. And then a separate filing is the notice of intent, which also has a 21-day time period for the commission to commence the hearing, and then a separate 21-day time period for it to issue after the hearing is over.
Could I ask a very quick question about that first part, which is the 21 days to commence a hearing? Now, I noticed that the Commission assumes, and it points to the waiver. In fact, the waiver is a waiver of the decision. It's called it's a deadline, and it speaks in terms of waiving the mandated 21-day decision deadline. So it really doesn't specifically address a hearing deadline, only a decision deadline. Do you agree? There is a next paragraph that says that the next available hearing it'll be scheduled at the next available open meeting date, but that doesn't necessarily say that it's not going to be within the 21 days as required by the statute. Do you agree with the Commission that the waiver is actually a waiver of both the 20-day hearing deadline as well as the decision deadline, which is the only thing specifically mentioned.
I think that the form is vague, so I'm not sure that I can answer whether it was intended to waive the earlier deadline. I think in a closer review of the record and all the different emails that were prior to that first hearing date, it would appear that actually the Conservation Commission followed the procedure that I described, which was that it opened the hearing within the 21 days. It had received an agreement from the applicant to then continue to the April 6th date, and then they proceeded with that. So I don't see
That's not
an
an
issue
issue
with
here.
the first 21-day period.
All right, thank you, Counsel.
Thank you very much, Your Honors.